very good day to one and all attending today's webinar on the gray areas of the Insolvency and Bankruptcy Code 2016 presented to you by Vaish Associates. I hope you all are fine and in good health. I am Drushan Engineer and I welcome you all to this webinar. I will be moderating this session along with my colleague Parth Mishra. Since the IBC was first introduced in 2016, it has undergone many amendments, and the IBBI, the legislature, and the courts have taken proactive steps in keeping the code relevant and answering questions that may have not been answered in the original draft of the code, but have cropped up in the course of its application and its implementation. Due to the IBC still being in its infancy, various circumstances have resulted in gray areas that have required clarifications in order for the stakeholders to correctly ascertain the nature of the corporate insolvency resolution process or liquidation process, as the case may be. Verily, a rolling stone gathers no moss. Over the amendments, the central theme of the IBC, which is to ensure that the corporate debtor continues to operate as a going concern and that resolution, rather than liquidation, is the preferred goal, has been kept in focus. However, despite the proactive and positive approach taken by the IBBI, the courts, as well as the legislature, there still exists some gray areas where there is no true certainty as to what is the correct position under law. Today, we are going to discuss these gray areas, keeping the principal goals of the IBC in mind. Our esteemed panelists for today's discussion are Mr. Bomi Daruwala, Joint Managing Partner, and Ms. Sandhya Iyer, Partner, based out of the Mumbai office of Vaish Associates Advocates. In order to keep the format of this session crisp and relevant, we have designed it in a question and answer session format. So without further ado, let us commence with the session. The first query is directed towards Bomi sir and is regarding interim finance. The question is that if it is possible to pay interest beyond 12 months from liquidation commencement date.
So let me give a background of this interim finance. The background is the definition in section 5, subsection 15 of IBC. And the definition reads as interim finance means any financial debt raised by the resolution professional during the insolvency resolution process period and such other debt as may be notified. So the latter part you can forget it because I am not aware of any notification. So we are talking of a debt raised during the insolvency commencement period, insolvency resolution process period. Now, insolvency resolution process period is defined in terms of number of days. So it says, section 5, subsection 14, says that it is a period of 180 days starting from the insolvency commencement date. Then in section 12, subsection 3, there is an extension of a period of 90 days. Now, what is the relevance of 180 days and 270 days, which is 180 plus 90? The relevance is that the approved resolution plan should be filed with NCLT before this period. But in an insolvency resolution process, apart from filing the approved resolution plan, there is the next process of approval of the resolution plan by the NCLT, and then there is the next process, which is the transfer date, when the actual transfer of the undertaking happens to the resolution applicant. Now, there is a big time lag between the filing of the resolution plan with NCLT and the actual transfer date. Unfortunately, the definition is linked to the number of days, and there could be a long period where interim finance may be required by the business of the corporate debtor, which is not captured within this definition of interim finance. So that is the first problem. Now, the second problem is that for the interest during the CIRP period, it is fine that that is part of your CIRP cost. But God forbid, if the corporate debtor goes into liquidation then in that particular case, what the liquidation cost definition says that interim interest on interim finance will be considered only for a period of 12 months or till the actual repayment of the interim finance. Now, the problem is that it is assuming as if the liquidation is going to get over in 12 months. The way it has been drafted is keeping in mind that they have kept a time limit of 12 months for the liquidation process. But within the regulations, for sale of an undertaking as a going concern, there is an additional period of 3 months. So even the liquidation regulations are contemplating a period of 15 months, but what the interest provision is saying that only we will consider interest up to 12 months or up to the date of actual finishing of liquidation, whichever is earlier. So there is an anomaly over here. Now, the way to do it is that when you want to seek an extension to liquidation process, you can always apply to NCLT, and while seeking extension, you can say that please allow me to pay interest for the period which is beyond 12 months and for during which the liquidation is continuing. But the question is that, for such an important thing like an interim finance, which may be required during the entire CIRP period or during the liquidation period, why should there be any fetters? I mean, it should be absolutely crystal clear that anything which is contributed by liquidation finance or by the interim finance, whether during the CIRP period or during the liquidation process period, it should qualify as CIRP cost or liquidation cost, and interest should also be correspondingly qualified. If you don't do that and if you keep this as a gray area, who's going to provide interim finance? Over to you, Drushman.
Thank you, sir. Our next question is directed to Sandhya ma'am. Can we compel COC members who are banks and financial institutes to contribute to CIRP costs or interim finance?
Good afternoon to everybody. So on this question, see, of late, in fact, we are seeing a lot of NCLT's ruling that COC members have to pay up the CIRP costs or contribute to interim finance. Now, this is a big dilemma for the financial creditors. Here you have a corporate debtor who has already defaulted and who's causing losses to you, and you are now compelled to throw good money after bad money. So now it may be a justification, contributing to CIRP costs and interim finance may be justified if you're certain about a resolution or you're sure that, with your security, you will be able to recover the money. But if it is not a certainty, then especially unsecured creditors, they would be a little reluctant and they would deliberate as to whether they should be contributing to CIRP costs and interim finance. Now, secondly, one more thing is we have also come across cases where even in liquidation, realizations have not been adequate to recover CIRP and liquidation costs. So what happens is you have contributed to interim finance, CIRP, liquidation costs, but the condition of the company is so bad that, a part of this itself is not recovered. So this is the risk. Now, what happens is, as a result, we are also seeing one more development, that some of these smaller banks and financial creditors who are smaller stakeholders and who are not very particular about voting rights are preferring not to file their claims because they say, okay, fine, we will not be a member of the COC and we don't have to contribute to the interim finance or CIRP costs. And they do this only in cases where they are sure that, okay, this is a case where there's going to be no resolution. This is all likely, in all likelihood, likely to go into liquidation. And at the liquidation stage, they will file their claim. So some of them are adopting this approach in order to save themselves from having to contribute to CIRP costs and interim finance. Now, let me also give a small overview of the case laws that we have seen in this regard. So firstly, there was Reliance Commercial Finance versus Noble Resourcing Business Solutions. This was decided by NCLT Principal Bench at Delhi. This was a simple matter where there was Intech Capital, which was holding 42.78% voting share. and they wanted that the CIRP costs should not be contributed upfront by them, but it should be at the end of the process after the recovery was made. And the COC, remaining members of COC had agreed to pay up the CIRP costs in advance. So NCLT directed them to contribute pro rata to CIRP costs, or else NCLT said that their claim would not be considered. And the reasoning of the NCLT was that if CIRP costs were not contributed, the whole process would come to a halt and cause delay. And that's why they directed that the FC should contribute to CIRP costs. Now, the second judgment was one of Committee of Creditors versus Zalta Food and Beverages. So this first went to the NCLT and then went to Ncaa as well. The brief, this one facts of the case was the corporate debtor was operating out of rented premises from a particular landlord, and this corporate debtor had placed a security deposit with the landlord. So what the resolution professional did was he moved to the COC requesting them to pay the rent for these premises, but the COC did not approve payment of the rent. So the RP had to make an application to NCLT. Now NCLT directed COC to pay the rent for the CIRP period, or they should make suitable arrangements in the alternative for other premises. So again, this matter went to Ncaa in appeal, and there the COC argued that outstanding dues is rupees 2 crores and security lying with landlord is 3.4 crores. So the rent can be adjusted from the security deposit. So Ncaa did not accept the argument on account of the moratorium that was operating under Section 14. And what Ncaa held was that the landlord cannot negotiate the security or adjust the security deposit. And as regards current rent payable during the CIRP period, the moratorium is not applicable for that. And therefore, the adjudicating authority was rightly held that the party should pay the rent during the CIRP period. So now, while some of the members did not, pursuant to the Ncaa order, some of the members paid up their contribution to the rent, but the others did not. So the matter again went before the NCLT, and NCLT ordered that in case of members who have not made any contribution to the CIRP costs, their claims are liable not to be entertained. So we have to see this, if you don't contribute to CIRP costs, your claims will not be entertained. So that is very, very important. Then, of course, there was the case of Jet Airways before NCLT Mumbai, where what had happened was the RP had filed an application seeking direction against the COC to sanction and disburse funds towards interim finance, which would help him to carry on his duty as RP without any delays. And NCLT ordered that RP is duty bound to maintain the corporate debtor as a going concern, and it passed an order to the members of the COC who had already sanctioned interim finance. They should disburse it immediately, and those who have not should get their sanction and disburse within 15 days. So this was a case where they were directed to disburse interim finance. A fourth interesting case was that of Muthoot Finance versus Southern Investments, which came up before Ncaa. And here what this Muthoot Finance, the financial creditor, argued is that they were merely a member of the COC and had not benefited from anything, benefited at all, but were being saddled with the burden of payment of CIRP fees. So here the COC had approved payment of CIRP fees, and they said later on, I think there was some settlement also agreed with the corporate debtor, and they said we will recover it later from the corporate debtor. But the Muthoot Finance was not willing to pay. So of course, this one Ncaa directed them that you cannot take the argument. They said that we are not concerned whether you have benefited or not. Once the COC has decided, it is the duty of the RP to take actions to raise interim finance subject to approval of COC. And once COC has fixed the fees and has approved it, then it's the duty of every member of the COC to contribute in proportion to their voting share. And you cannot argue that it is not recoverable or come up with any other arguments, and they were directed to pay up their amount. And the last judgment that I'm going to discuss, which is a slightly different, is an Ncaa judgment in the matter of Edelweiss ARC and Sai Agency Regency Power. So the brief facts of this case was that there was a gas supply agreement with GAIL which was due to expire on 6th August 2019, and GAIL had asked the corporate debtor to submit a letter of credit. So the COC had approved interim finance, and one of the financial creditors, PNB, was willing to provide interim finance if all the other financial creditors issued a letter of comfort in its favor. So in this case, EARC argued that it cannot be forced to contribute or incur further liability under CIRP, and only the secured creditors should be asked to contribute. So what Ncaa observed here was that EARC was not ready to release the letter of comfort, and this default would have rendered the corporate debtor ineligible to participate in the tender before bail for power supply, for which the last date had been fixed, and thereby it will affect the going concern. So what Ncaa observed was that this appellant, EARC, has itself sought to be a part of COC and joined it. Nobody forced them to file a claim and be a part of COC. So if the appellant is a part of COC and wants to remain a part of COC, they cannot expect to claim only benefits from the process and claim that they would not take up any of the liabilities or responsibilities. So in COC meeting, the appellant did have a right of dissent, but once the majority took the decision, then all members were bound by such decision. And Ncaa said that it will not interfere in the collective decision of COC for contribution towards CIRP costs or interim finance, and the dissenting financial creditor cannot be allowed to scuttle the process, and they must pay up. Of course, this Edelweiss ERC decision and appeal has been filed in the Supreme Court, which is pending. So it would be interesting to watch what the outcome is, because I think there is a kind of interim stay where they've been asked to proceed without insisting on letter of comfort from ERC. So this would be an interesting judgment to follow. So I hope that answers your question, Rushan.
Thank you, ma'am. The next question is directed to Mr. Daruwala and is regarding first and second charge holders, and if their rights have to be recognized in CIRP and in liquidation.
So, there is a recent amendment in section 30, subsection 4 of IBC. And pre that amendment, NCLAT was invariably taking a view that you can't discriminate between unsecured financial creditors and secured financial creditors. And this dispute became a very big dispute in the Hisar Steel case, where the lenders like State Bank were regarding Standard Chartered Bank as an unsecured creditor, and NCLAT had held in favor of Standard Chartered Bank. After the NCLAT judgment, section 30 subsection 4 got to be amended, and the revised section says the committee of creditors may approve a resolution plan by vote of not less than 66% of the voting share of the financial creditors after considering its feasibility and viability. And here the important part comes: the manner of distribution proposed, which may take into account the order of priority among the creditors as laid down in subsection 1 of section 53, including priority and value of security interest of the secured creditor. So essentially, by this particular provision, they said that the default situation is to follow the waterfall mechanism under 53 if you are distributing the amounts which are stated in the resolution plan. And by using these words, including priority and value of the security interest of the secured creditor, they have clarified that in the waterfall mechanism, the first charge holder will have a higher priority, the second charge holder will have the next priority, and then the unsecured charge holder will have the unsecured financial creditor will have the priority. So essentially, this particular provision has recognized the distinction between the first charge holder and the second charge holder during the CIRP process in respect of distribution of the resolution amount. Now, if you carefully see the language of subsection 4 of section 30, it says the manner of distribution proposed which may take into account. And this may is a crucial word. The legislature could have used the word shall, but it refrained from using it and it said may. Because if it had used the word shall, then in that particular case, in most of the cases, operational creditor would have got 0. Because when the financial creditor itself cannot get full value, where is the question of operational creditor getting some value? So the essential interpretation of this is that if all members of COC agree, then something will get paid to the operational creditor. But otherwise, if somebody disputes the priority, then you will have to follow the priority which is there, and it will of course be the 66% majority decision of the COC. Now coming to liquidation, in case of liquidation, you have this section 53. Now, you know, one of the things which the Insolvency Law Committee report said in 26 March 2018, when they came out with the report, they didn't clarify that you can make a distinction in section 53 between the first charge holder and the second charge holder. However, they gave a hint that that is the intent, because they talked about priority inter se between the secured creditors, and they said that the valid intercreditor and subordination agreements will continue to govern the relationship. But I would say the more clear proposition in this regard came in the Technology Development Board versus Anil Goel case, which was decided by NCLT Ahmedabad in 2020, where based on an old Supreme Court decision in ICICI Bank versus Sitco Leathers, they decided that yes, the first charge holder will get a priority over the second charge holder. Now there, they were asked to interpret section 53 subsection 2, because section 53 subsection 2 has a language which says any contractual agreements between recipients under subsection 1 with equal ranking, these are the crucial words, with equal ranking, if disrupting the order of priority under subsection, shall be disregarded by the liquidator. So in this case, the second charge holder tried to give an argument that I am also a charge holder, I am also a financial creditor, so you give me equal treatment. But the NCLT said the crucial words are of equal ranking, and a first charge holder and second charge holder can never be considered as people of equal ranking. And they said that 53 subsection 2 does not come in the way of the first charge holder getting priority over the second charge holder. Over to you, Drushan.
Thank you. The next question is also directed towards Mr. Daruwala. In the event where there is an operational creditor to whom a corporate debtor owes some pre-CIRP dues, when the operational creditor makes it clear that unless these pre-CIRP dues are paid, they will not continue to provide the services or goods. If the provisions of goods and services stop, then the unit will come to a halt. Will one make payment of such pre-CIRP dues in that case?
So this is a very good question, and actually, you know, this concerns a lot to the RP, because RP is under an obligation to continue the operations as a going concern. Now, if some important creditor or if some important customer goes away, how do you continue the operations? And many of these creditors, they try to arm twist for their pre-CIP dues. But let us see what is the legal position. So in Ved Prakash Abbott versus Kishore Avarsekar, it was a case before the Delhi High Court. Now there what happened, that there was a compromise decree and corporate debtor had to pay under the compromise decree, and it entered into CIRP. So since it was a pre-CIRP due, the corporate debtor stopped the payment. So the creditor, you know, he approached the court saying it's a contempt of the court. So the court said, no, it's not a contempt of the court, because IBC is an overriding law in case of any conflict between legislations. And, you know, pre-CIRP dues, the RP cannot pay in priority to one creditor. This pre-CIRP dues will have to be paid as part of the resolution plan. So pre-CIRP dues are not allowed to be paid. Then there is a second case in 2020. This is a IBBI order, and it's a disciplinary case against the RP. And this is in case of Mr. Mohanlal Jain. Now there, the RP, he took the precaution of taking consent of the COC, and he was paying the EMI dues to HDFC. And you know, this became an issue before IBBI, and IBBI said that it is wrong. Even though you have taken consent of COC, this is not a matter which you should have taken consent. It's a pre-CIRP due. You should not have paid it. So the legal position is that the pre-CIRP dues cannot be paid. Now, legislature has rightly recognized, you know, this could create issues. So what it has done is that it has introduced in the moratorium section, which is section 14, it has introduced subsection 2. Now, subsection 2 says the supply of essential goods and services to the corporate debtor, as may be specified, shall not be terminated, suspended, or interrupted. Now, what is this essential services? It's not anything under the sun. It says whatever is specified, and it has been specified in Regulation 32, and there are only 4 elements which have been specified, which are electricity, water, telecommunication services, and information technology services, that too with conditions. It has been specified. So what happens to the other services? So fortunately, there is a subsection 2A of section which says that RP can additionally determine that what are the other essential goods and services. But there again, you know, they have put a condition that all the dues for these so-called essential services which are determined by the RP should be paid during the moratorium period. So whatever is the payment which is due during the moratorium period, that has to be paid. Then only the RP's categorization of essential goods and services will work. Now, the legislature has taken care of the supply side of goods and services. Unfortunately, they have not taken care of the customers. We have a case presently where the customer is, and he's a major customer, and frankly, if he stops doing business with us, then the value of the business will go down significantly. So you can't afford to lose the customer, but he's arm twisting. And so, you know, the point which we are saying is that, and what is the arm twisting? Actually, from a customer, you have to recover money. But what he's arm twisting is that in case of that customer, there were some certain subcontractors who were engaged by the corporate debtor to do the work. And for those subcontractors, since it was pre-CIRP dues, we were not paying it. But the customer says that I will not do further business with you till you pay these subcontractors, because we also have a relationship with these subcontractors. So that becomes sometimes a tricky situation in that particular case.
Thank you, sir. The next question is directed towards Ms. Iyer. We are seeing several instances now of retired employees of banks being appointed as resolution professionals by the bank. Can such an RP be truly independent, and can he take care of the interests of all stakeholders?
Yeah, Drushan, yes, we have been seeing some banks which are increasingly appointing their ex-employees as the resolution professional. Now, there is no explicit statutory restriction as such anywhere provided in the code or any rules or regulations. The law only provides that an insolvency professional has to disclose his relationship with the financial creditors and other stakeholders. So, in the past, NCLT member had NCLT Mumbai had an petition to adjudicate on this issue, wherein this contention was that RP was an ex-employee of the financial creditor, was not accepted by the tribunal. But however, very recently on 22nd of May 2020, Ncaa has held to the contrary in the case of SBI versus Metaner Limited. And this is a very, very interesting judgment. So what happened there was that this RP, I mean, the corporate debtor objected to the appointment of IRP on the ground that this IRP was had worked with State Bank of India for 39 years before his retirement in 2016. He was drawing his pension from State Bank of India, and therefore he was on payroll of financial creditor as per Income Tax Act, and that he had retired in a senior position as CGM in 2016, and therefore there is an apprehension of bias, and the RP was unlikely to act fairly and could not be expected to be an independent umpire. So on these grounds, Ncaa held that, you know, they directed that the IRP should be changed. So SBI appealed before the Ncaa, and the arguments of Ncaa were fivefold. Interesting. Firstly, they said IRP is not required to act as an independent umpire between the financial creditors and ex-management of the corporate debtor or decide any conflicting issues between them. Secondly, they said no adjudicatory powers are there vested in the RP, and he only acts as a facilitator in the CIRP proceedings, as all major decisions are taken only with the approval of COC. Thirdly, they said that even financial creditors, they play their part only to the extent of its voting share. So in this case, SBI can take decisions only to the extent of its voting shares as member of COC and not beyond that. Fourth issue was that merely because the proposed IRP happened to be an ex-employee of a financial creditor, it cannot be a ground to allege bias against him. And lastly, they said the proposed IRP was not on any panel of the appellant bank, and that he had no role in any decision making of the appellant bank. So what NCLT held was that the argument advanced on behalf of the corporate debtor to portray this IRP as an interested person drawing salary within the meaning of Income Tax Act, it defies logic and it has to be repelled. So that was not accepted. That argument was not accepted by Ncaa. Ncaa observed that on the merits of the case, there is no prohibition against eligibility of a former officer of a financial creditor for appointment as RP post his retirement, even if he avails pension benefits from the FC. However, Ncaa interestingly held that, you know, if there is such an apprehension on the part of any other stakeholder, though it may not be true or it may not be a proven fact, it's just an apprehension, the same must be given due consideration. And in the light of that, Ncaa declined to interfere with the order of the NCLT, and they directed the change for RP on the apprehension that he may not act fairly. Now, so after having said this, so let us just come down to what are the things that Ncaa said. And I think they relied on one Supreme Court judgment, which I find quite interesting, that when you are deciding the test of likelihood of bias, what is relevant is the reasonableness or apprehension in the mind of which party. So no, you have not got to look into the mind of the financial creditor who appointed and decide whether there is bias or not, but you have to look at the mind of the opposing party, that is, you know, the other stakeholders, and do they perceive bias or not. And that was their ground for holding that yes, this is a situation where the other stakeholder, corporate debtor, was justified in sort of apprehending that there could be some kind of bias. So this was the logic. So, you know, to just put it briefly, that you should not only be unbiased, but also you should appear to be unbiased. So I think that is the principle I would draw from this. So coming to that, now what are the laws regarding this? So if you see, there is an IBBI circular of 16 January 2018, which requires IRP to, RPs to disclose all their whatever, you know, connections or relationships that they have with the various, with the financial creditors, corporate debtor, and various stakeholders. So if you also look at the code of conduct of the, which is in the first schedule to the insolvency professional regulations, there are certain important things that I will read out in the context of this judgment. It was not examined in this particular judgment, but I thought we must keep this in mind while discussing this issue. So firstly, an IP must maintain complete independence in its professional relationship and should conduct insolvency resolution, liquidation, or bankruptcy independent of external influences. then an IP must act with objectivity in his professional dealings by ensuring that his decisions are made without the presence of any bias, conflict of interest, coercion, or undue influence of any party, whether directly connected to the insolvency proceedings or not. Third one is, an insolvency professional shall disclose existence of any pecuniary or personal relationship with any of the stakeholders entitled to distribution under Section 53 and the concerned corporate person or debtor as soon as he becomes aware of it by making a declaration. And lastly, an insolvency professional shall disclose whether he was an employee of or has been on the panel of the financial creditor of the corporate debtor, or any IPA or any other relationship that he had, and the same has to be published. So now if you ask me my own analysis of this, see, one of the objects of the code is balancing the interest of all the stakeholders. So if I worked for 39 years in a bank and I'm drawing pension, I mean, one cannot rule out a suspicion in the other person's mind. So IPs are one of the 4 pillars of IBC, and they must all be above even the slightest a link of any kind of suspicion by the others. The other 3 pillars are IBBI, NCLT, and IUs, which are all completely independent entities. Now, if you just look at NCLT, suppose a member of NCLT has worked for 25 years with a financial creditor, he would have to recuse himself from hearing matters of that financial creditor. So why should that not apply to the IP? So, as I said earlier, RP must not only be independent, but he must also appear to be independent, and all stakeholders must have faith in them. So I think in that perspective, what I would say is, like, for example, maybe you should think of some threshold. Like, if you hold more than a certain threshold of voting rights, you should not appoint your ex-employee as the resolution professional. But I think some thought needs to go into this, whether, you know, we need to stop this increasing practice of appointing ex-employees as resolution professionals. So I hope that answers the question.
Thank you. It does. The next query is also for Ms. Iyer. The question is that how does one deal with claims made by any creditors in respect of disputes pending in courts? For example, if the creditor has filed a suit for damages in court and filed a claim in respect of the damages.
Okay. This has been examined by the Supreme Court in the SR Steel judgment, where it was held that RP is required to collect, collate, and admit claims. And if the claims are not capable of being quantified, say on account of an ongoing dispute, then the RP can admit the claims at a notional value. And this is the practice that has been followed, that if in case of such disputed claims, it has been accepted at a notional value. Now, there is an interesting judgment of Tata Steel before the Bombay High Court, wherein the question that had come was the resolution applicant, whether the resolution applicant petitioner was justified in contending that upon CIRP being triggered under the code. So what had happened here was that there was some legal proceedings which was pending or filed by the operational creditor against the corporate debtor, and that was proceeding before some smaller court. It was some district court, I think. And the respondent number 1 had participated in the CIRP proceedings. So the resolution applicant, who was the petitioner, argued that once you have participated in the CIRP proceedings, then it is deemed that, you know, the suit of recovery that you had filed before the other court will no longer survive. So this was the issue that had to be decided. And the question was, when they had filed an application before the trial court on this issue, the trial court had dismissed the resolution applicant's suit, and they had held that no, these proceedings can continue. So the contention which was raised on behalf of the petitioner, it was based on the assertion that IBC has overriding effect over other laws. And once CIRP has been triggered in the context of the petitioner in the present case, it will render all other proceedings as not maintainable and liable to be dismissed. So what the court held in this case was that, such a dispute. Now, there was another interesting thing in this case that, they had decided in this Tata Steel, that it was Bhushan Steel case, that in case of all sub judice claims, they had set up a corpus where the matter was yet to be decided. They had set up a corpus and the monies were to be distributed from that corpus. So what the court held, Bombay High Court held, was that such a dispute which not only existed, but it was recognized as a sub judice claim for which there was an inbuilt mechanism which was incorporated in the resolution plan, cannot be extinguished, but you have to follow the process that was set out in the this one, whatever is the mechanism that you have set up in your resolution plan. So, what we would always recommend is when there are such sub judice claims, it is always better to sort of admit them at some notional value rather than creating these kind of corpuses, because with these kind of corpuses, you could end up with a lot of disputes. Yeah, so that is the response.
Thank you. The next query is directed towards Mr. Daruwala. Is it time to do away with Section 29A or to modify it somehow to permit related parties subject to the right of being capped?
So, 29A has a history that it got introduced because what the government found that through backdoor, the promoters are trying to get control over the company at a discount. So it had a good objective that, the people who are defaulting, they should not find a backdoor entry into their company, and they should have a fear of losing their company if they default. But Section 29A, the way it is worded in the widest possible manner, because it covers the defaulter acting jointly with the resolution applicant. It covers the defaulting person acting in concert with the resolution applicant. And it also covers a defaulting person who is a relative with the resolution applicant. So it is the widest possible language which has been put. In fact, the Insolvency and Bankruptcy Committee said that, look, this is very, very wide and brings too many people under its sweep. So why don't you narrow it down by removing the words persons acting in concert and simply saying that if a defaulting promoter joins hands with the resolution applicant to acquire shares or control of the corporate debtor, then such a kind of a person will not be eligible to be a qualified resolution applicant. But this suggestion of narrowing down the breadth of Section 29 was not accepted by the government. Now, in case of liquidation, again there was a window for the promoters to come in, and they found the window because the NCLT and NCLAT held that you could have schemes of compromise and arrangement under sections 230 and 232 of the Companies Act, and in that compromise or arrangement there was a window for the defaulting promoters to come in. So this is very interesting to note that IBPI in a consultation paper in April 2019, and these are the observations which I think I should just read it out so that you know what was the thinking of IBPI to try to relax the applicability of 29A, at least in case of liquidation. So they say that proviso to section 35 subsection 1F of the code mandates that the liquidator shall not sell immovable and movable property or actionable claims of the corporate debtor in liquidation to any person who is not eligible to be the resolution applicant. This prohibits persons ineligible under section 29A. However, the law does not prohibit such ineligible persons to participate in compromise or arrangement under section 230 of the Act. It may be necessary to harmonize the provisions of the code and the Act to provide a level playing field. Some stakeholders feel that ineligibility norms under 29A of the code may also apply to compromise or arrangement under section 230 of the Act. Other stakeholders feel, unlike liquidation under the code, which is liquidator driven, the compromise or arrangement under the Act is mostly driven by the tribunal. Further, 29A of the Code has several exceptions, while Section 230 of the Companies Act deals with all kinds of companies in all situations. There will be practical difficulties in implementation of ineligibility for purposes of Section 230 of the Companies Act. Therefore, it is proposed that the ineligibility norms under Section 29E of the Code may not apply to compromise or arrangement under Section 230 of the Act. So this was suggestion of IBBI, but this suggestion was not accepted by the government. What the government instead did was it tightened the liquidation regulations to bar the people who are disqualified under Section 29A to even get the company through the scheme of compromise or arrangement under Section 230 of the Companies Act. So the present thinking of the government as well as the Supreme Court in the Ncaa Steel case is that 29A has to be interpreted in the widest possible way. And that's the way it is framed and that's the way it is interpreted. In fact, the Supreme Court in Ncaa Steel case, it even went to the extent of lifting the corporate will to see whether Section 29A is complied with or violated. So that is the length and breadth of 29A in its applicability at the moment. But the government gave a hint, because when it made an ordinance of 2020 to suspend the IBC process because of the COVID, it writes in its preamble, it is difficult to find adequate number of resolution applicants to rescue the corporate person who may default in discharge of their debt obligation. So they are recognizing the reality. I think there is a need to rethink on 29A, and I think that there is a need to make a distinction between willful defaulters and the promoters who have fallen victim because of external circumstances. I think that the willful defaulters can still be barred, but as far as the promoters who have fallen victim of the external circumstances, I think we should leave it to the wisdom of COC and the RP whether they would like to invite such kind of people to submit the resolution plans for revival of a corporate debtor.
Thank you. The next question is also directed to Mr. Daruwala. Is there a bar on a resolution applicant selling the corporate debtor to the erstwhile promoters after implementation of the resolution plan?
See, under IBC, the 29A bar only applies till the submission of the resolution plan, and it has to be tested at the time of submission of the resolution plan. This is also held by the Ncaa Steel case. So technically, after implementation of the resolution plan, the resolution applicant is free to sell the business to anybody, including the so-called defaulting promoter. But there are some process documents which the RPs release, where we see that there is a condition which is put that for a certain number of years, the resolution applicant cannot sell to people who are disqualified under Section 29. So long as the process document does not contain such a restriction, there is no bar. Having said that, one more thing I would like to point out, that the test of Section 29A is actually applicable on the date of the submission of resolution plan. Legally speaking, I'm not saying how it will be perceived, that's a different issue. But legally speaking, as per the present language of 29A, if there is a subsequent negotiation and agreement between the defaulting promoter and the resolution applicant, which happens from the date of submission of the resolution plan and even before the business is transferred to the resolution applicant, technically that is also not barred under Section 29.
Thank you. The next query is directed towards Ms. Iyer. Once a resolution plan is implemented, is there an obligation cast on the resolution professional to pursue the avoidance transactions? Similarly, once a company has been liquidated, is there an obligation cast on the liquidator to pursue said avoidance transactions?
So, Drushansi, in most of these, IBC proceedings, we have seen that promoters and suspended directors do not cooperate either with the RP or the transaction document. And many times the transaction, one is it's delayed substantially and it's difficult to meet the deadlines under the code. And the second thing is many a time the transaction audit report itself is not conclusive due to non-availability of documents. So what is the position of law? So section 25(2)(j) of IBC, it casts a duty on the RP to file application for avoidance of transactions in accordance with chapter 3, if there are any such transactions. Then section 35(1), the liquidator has the power to and the duty as well to investigate the financial affairs of the corporate debtor and to determine undervalued and preferential transactions. So it is restricted to undervalued and preferential transactions as far as liquidator is concerned. But I would say that even if there is a fraudulent transaction which comes to the notice of the liquidator, which the RP has not noticed, I think there is a duty on the liquidator to also investigate into such fraudulent transactions. And regulation 35(a)(1) of CIRP regulations, it sets the timelines. So it says that on or before the 75th day from insolvency commencement date, the RP should form an opinion whether CD has been subjected to any avoidance transactions. Then by the 115th day, they have to make a determination. And by 135th day, they have to make the application to the NCLT. As I said earlier, it is difficult to meet these deadlines because the promoters and suspended directors do not cooperate. Now, another interesting thing is that we have seen that section 23 of IBC now provides that the resolution professional shall continue to manage the operations of the corporate debtor even after expiry of CIRP period until an order either for approval of the resolution plan is passed under 31 or liquidator is appointed under section 34 by the adjudicating authority. So till such time the term of the RP comes to an end, there is a duty on him to see that this application for avoidance transactions is pursued. But what happens after that is the gray area. One doesn't know because the code is completely silent on that. Now, in fact, in this insolvency committee report, which was released in February 2020, this issue was deliberated upon. And I will just read out certain relevant portions. So it was noted that timelines for completion of proceedings on avoidable transactions or improper trading has not been stated in the code. That is when it should end. It starts as to when it should commence, but it doesn't stipulate when it should end. So the committee considered if strict timelines for initiation and completion of such proceedings should be introduced in the code, and the committee agreed that prescriptive timelines for initiating proceedings against avoidable transactions and improper trading during CIRP or liquidation may not be necessary. So as a general rule, they said these proceedings would have to be initiated by the RP during CIRP or liquidation process within the timelines provided in the respective regulations. And if the resolution plan in a CIRP, they said that even a resolution plan in a CIRP may provide for preservation of claims and manner of pursuing these proceedings. So now the important issue that comes up is that how are these litigation costs for pursuing these avoidable transactions to be funded? So in most cases, avoidance applications will continue beyond the CIRP timelines, that is after the term of the RP comes to the end, an end, and you have to now contemplate how it is going to be funded. So it would have been nice if the law had provided, like for example, if the COC feels that okay, these are the preferential transactions or fraudulent transactions where I have a very strong case and I can recover the money, they contribute to the litigation cost, pursue it, and when the money comes in, then they distribute it among themselves. Similarly, a resolution applicant can also provide, they feel that okay, these are preferential transactions and I can make out a strong case that this is a preferential transaction and recover it. So they also can provide in the resolution plan that okay, we will pursue these cases, we will fund the litigation, and when it comes, it should come to us, and that can be provided in the resolution plan. but the law is silent on what happens later on. So maybe it will be advisable to provide as to how who is going to fund these costs. So that is very important. So what we would suggest is maybe in resolution plans one can consider allotting a fund for litigation costs, and there it should also be provided as to if you are able to recover how the money will be distributed. And the same is with the liquidation also. So just before this dissolution, maybe the liquidator should tie up with the counsel who has filed the avoidance applications, fix up some fee and set up a corpus for that, for continuing the avoidance transactions. That is what can be done for the present till such time there is some clear provision which is provided under the laws. Yeah, that's my answer.
Thank you. The next question is also from Ms. Iyer. Are the creditors permitted to sell off assets belonging to a corporate debtor lying with the creditor and only filing the net claim?
So you are talking of set off, not sell off. Set off assets belong. Yeah.
Yes.
So what happens is, I think there are two interesting judgments on this issue. One of them is this Indian Overseas Bank versus Dinkar Venkat Subramaniam, which was the Amtech auto case. So what had happened was there was a balance of about 6 odd crores which was lying with the Indian Overseas Bank, and the IRP requested that this money should be transferred to the account which he was operating with another bank. And IOB responded stating that the amount available in the current account is neither a security interest nor is it an asset of the corporate debtor, and therefore they are not liable to release that amount to the RP, and they will appropriate it towards the dues which are payable to them. So this was the stand which was taken by them before the NCLT, and NCLT rejected their stand and directed them to hand over the amounts because they said the money belongs to the CD, and during the moratorium you cannot appropriate any of that. It has to be handed over to the resolution professional. So IOB had filed an appeal before the Ncaa for this, and Ncaa held clearly that after admission of an application under Section 7, once the moratorium has been declared, it is not open to any financial creditor or any other creditor to recover any such amount from the corporate debtor, and it cannot also appropriate it towards its own dues. And if CD has borrowed some money from IOB, then they should file their claim before the IRP, and they should transfer this money, that is the amounts lying in the current account, to the resolution professional. So this was what the Ncaa held in the case of Indian Overseas Bank in the Amtech auto matter. So now it is pretty clear that at least unless this is set aside by the Supreme Court, that if there is a deposit which is standing in the name of the corporate debtor and it has not been appropriated before commencement of CIRP, then that has to be handed over to the resolution professional. But there is an interesting judgment of Bharti Airtel, which was after this Ncaa judgment, and it had also considered this Ncaa judgment. So let us just go briefly into what this Bharti Airtel case was. So the fact of this case was that an application was filed by Bharti Airtel, which was seeking directions to the resolution professional to honor the legal and equitable right of Bharti Airtel to set off an account on account out of 112 crore rupees during CIRP. So the background was that Airtel, this was between Aircel and Airtel. So Airtel was holding about 450 odd crores amount, which was the amount belonging to Aircel. Airtel had issued certain guarantees on behalf of Aircel on the condition that if and when Aircel cancelled and returned the guarantees, Airtel will return the 453 crores to Aircel. So there was some Supreme Court or TDSAT decisions which said that these guarantees were all released and discharged, and so Airtel was required to release this 450 crores. So while releasing this 450 crores, what they did was there were some unpaid invoices which were unpaid by Aircel. That was 112 crores. They set off that 112 crores and returned only 340 odd crores to Aircel. So then what had happened was this decision was challenged before the NCLT Mumbai, And what NCLT Mumbai held was pretty interesting. I think there are 2-3 points that they brought out. What they said was, if you look at section 18(1)(f) of the code, IBC, it states that the IRP will take control and custody of any asset over which the CD has ownership as recorded in the balance sheet of the CD, but that is subject to the exceptions which are provided in section 18. And one of the exceptions is that an asset which is owned by a third party, which is in possession of a corporate debtor held under trust or under contractual arrangements, will not be affected by 18(1)(f). So that will IRP need not take control over that. And therefore, the resolution professional can take control over an asset belonging to or in the possession of the corporate debtor. But the exception is that if the asset, although in possession of corporate debtor, but if it is held either under trust or under a contractual arrangement, the RP cannot take possession of that. So that is one point that the NCLT Mumbai held. Then there was one more argument that under Regulation 29 of Liquidation Regulations, there is a provision that where there are mutual dealings between the corporate debtor and another party, the sums due from one party shall be set off against the sums due from the other to arrive at the net amount payable to the corporate debtor or vice versa. So Aircel argued in this case that there was no corresponding provision in the CIRP regulations, and therefore this full amount, Airtel should not withhold any amount, and the full amount of 450 crores should be paid to them. So to this NCLT observed that if you look at Form B, which is supposed to be the submission of claim by the operational creditor in CIRP proceedings, there is a clause 8 in Form B which says, and this is during CIRP proceedings, which says that details of mutual credit, mutual debit between corporate debtor and creditor are required to be informed, which may be arrived by set off against the claim. So NCLT said that the amount of claim in Form B is not gross amount to be furnished by operational creditor, but it's only the net amount after setting off the respective claims. And so as a result, NCLT drew the conclusion that the Form B which is submitted itself gives an entitlement to Airtel to net off the amount. So this was the second thing that they said. And they also NCLT came up with another argument for permitting this set off, and that was that it said that even at the CIRP stage, when a resolution plan is to be examined, it is to be examined keeping in mind provisions of Section 53. That is, distribution of assets under Section 53 is to be kept in mind. So a resolution applicant, while submitting a resolution plan, is authorized to keep in mind the net values for which provision is supposed to be made under 32 of the code. And while submitting a resolution plan, he can keep the distribution under Section 53 in mind. And therefore, NCLT held that there is no specific bar or barrier in the insolvency code that during CIRP process, only gross amount is to be taken and netting is not permissible. So in this Airtel case, netting was permitted. So now you have two conflicting judgments. Ncaa is supposed to prevail, but subsequent to that, you have an NCLT judgment which has tried to make a distinction between this one and the NCLT ruling. It's not directly made a distinction, but one can infer from there. So therefore, I think there is definitely going to be a controversy and uncertainty as to, when you can, it's subjective as to when there is a contractual arrangement, when it is in trust and when it is not in trust. So therefore, I think it would be very good if, the CIRP regulations can come out with some kind of clarification on when set off is permitted and when it is not permitted. Like if you look at all the banks now, for most of their letters of credit, letters of guarantee arrangement, their sanction will provide that there must be a margin or a security deposit of 10%, 15%, 25%. So the problem is, operationally, many a time they may not set it off before CIRP, and even on the date of CIRP, this amount may be lying in the security deposit or margin account. So I think some clarity needs to be brought in as to whether these amounts, set off should be permitted. So I think some clarification in CIRP regulations would be very, very useful here.
Thank you.
Yeah.
The next query is for Ms. Iyer. It is that our creditors who have not directly lent to the corporate debtor but hold a mortgage or a guarantee or some other charge are only required to be treated as creditors and not as financial creditors pursuant to the Jaypee judgment.
Yeah, actually, this is very interesting, and there is a lot of controversy over this at present. So prior to the ruling of the Supreme Court in the Jaypee case, there have been various orders by NCLT and Ncaa in favor of the proposition that third-party mortgages or guarantees shall also amount to a security interest, and they will constitute a financial debt, and thereby they permitted such parties holding the benefit of the security interest to be treated as financial creditors under the code. NCLT had held in one case that mortgage to secure third-party facility amounts to a financial debt, and even Ncaa has held that guarantee given by a corporate debtor is a financial debt within the meaning of 5(8) of the code. Now, having said that, the Jaypee ruling has clearly cast a doubt, a shadow over all these arguments. And what Jaypee said is that a mortgage security, that is a third party, which is holding a mortgage security, is not a financial debt. And thereby, Supreme Court has narrowed the scope and interpretation of this term financial debt as defined in Section 5(8) of the IBC. And it has held that in order to qualify as a financial debt, it should represent disbursement of certain amounts to the corporate debtor against time value of money. So this was the basic issue over which there is a dispute. And the Supreme, of course, you must remember that the Supreme Court decision in the case of Jaypee was in the context of a mortgage. So the Supreme Court had analyzed the definition of financial debt in Section 5(8) in the context of only a mortgage. It did not consider a guarantee. And Supreme Court specifically analyzed the words financial debt, opening paragraph of the definition of financial debt, which says that financial debt means a debt along with interest, if any, which is disbursed against consideration for time value of money and includes 1, 2, 3, 4, I think A, B, C, D, E, F, there is up to I. What Supreme Court essentially held was that Section 5(8) enumerates various categories of financial debt under A to I, and mortgage doesn't fall under any of them. So therefore, again, mortgage does not meet the requirement in the mortgage by a third party, does not meet the requirement in the opening paragraph that it should have been disbursed against consideration for time value of money. So what happens is the money has been disbursed to the corporate debtor, and it's not disbursed to the person third party providing the mortgage. So you do not meet the criteria in the opening paragraph of the definition of financial debt. So this was the argument there, and they said that okay, you don't meet the criteria in the opening paragraph, you don't fall under A to I, and therefore beneficiary of a third party mortgage is not a financial creditor. And this was the basic logic. But now what has happened is now there is a raging controversy that Jaypee judgment should not only apply to mortgages, it should apply to all guarantees, pledge, third-party guarantees, third-party pledges, third-party hypothecation. Now, I can understand that you say Jaypee judgment should apply to third-party hypothecation and third-party pledge because that is very similar. But and especially where there is no guarantee. But wherever there is a guarantee, in my view, the Jaypee judgment will not apply. Though there is a lot of controversy and there are two views on the subject. And again, this will have to be settled by maybe the Supreme Court. So according to me, of course, as I said, Jaypee judgment will apply where CD has, where he has provided a third-party mortgage, pledge, or hypothecation, where it is not accompanied by a corporate guarantee. And in these cases, the financial creditor will not be treated. Sorry, this beneficiary of the mortgage or the security will not be treated as a financial creditor. Now, one thing you have to remember is if you are arguing that the provider of a third-party guarantee should not be treated as a financial creditor, then you have to explain why Parliament has incorporated subclause I in the definition of financial debt, which provides that it includes the amount of any liability in respect of any guarantee or indemnity that has been expressly included in I. And if you are arguing that no beneficiary of a guarantee is not a financial creditor, you have to explain why Parliament has incorporated 5(8)(I). So in my view, this controversy is yet to be, I mean, it's going to go on till maybe the Supreme Court decides it in some appeal.
Thank you. The next query from Ms. Iyer is that whether a financial creditor holding a negative lien in their favor should be treated as a secured creditor.
On this topic, we have not come across any judgment directly dealing with this issue, but we have, I mean, received a lot of questions on this, whether a negative lien should be treated as a person holding a negative lien should be treated as a secured creditor. So what is a negative lien? A negative lien in a document is just a covenant which says that the corporate debtor will not create any encumbrances over any particular assets without the consent of an existing lender. So that is not creation of any kind of security. But just take the example. Suppose there is an immovable property where I have maybe there is a immovable property, there is a covenant by the corporate debtor that they will not dispose it, and I go and register it with the ROC and I register it with the sub-registrar of assurances, then possibly I could argue that I have created some kind of interest in that immovable property and therefore my interest should be recognized. But in most cases of negative lien, there is never any creation of any kind of charge over this. Either if in the case of movables, they don't create a charge in favor of charge before the ROC, and in the case of immovables also they never create any charge in the sub-registrar of assurances. So negative lien is not a positive act of creation of charge. So hence I think it is going to be very, very difficult to argue that a negative lien is, I mean, a person holding a negative lien is a secured creditor. Anyway, there are some entities which are arguing on this line, and one has to see how this one courts rule on this. But my view is the courts will not hold that the negative lien is holder is a secured creditor. One more interesting aspect is commonly, as I said earlier, many of the banks, while opening letters of credit and guarantee facilities, they create a lien over the FDs. And this lien, what they do is they have a letter of lien. So a lien is actually created, and these lien holders have also been claiming that they are secured creditors. Now, because they have a letter of lien is nothing but a charge, they may have a better case to argue that they are secured creditors. But you have to remember one thing, that in the case of all companies, there is section 77(3) of the Companies Act, which provides that no charge which is created by a company shall be taken into account by a liquidator unless it is registered and a certificate of registration is issued by the ROC. So you have to remember that as far as your letter of lien, the practice is that for letter of lien, nobody files a charge with ROC. So you have to remember that under the Companies Act, the liquidator has fully entitled to refuse to recognize a letter of lien where there is no filing with the ROC. Now, there is also a provision under section 52(3) of IBC and regulation 21 of liquidation regulations, which says that the existence of a security interest has to be verified by the RP in one of the following manners. Either they have to verify it from the records of the information utility, or from the certificate of registration issued by ROC, or any proof of registration with CERSAI. So as far as IBC is concerned, if you have a letter of lien which is recorded with any of the three people, then you can argue that you have a charge over it. But when it comes to the Companies Act, so far Companies Act has only provides for ROC filing. So I think it is safe, if you have a letter of lien, it is safe to register that with ROC as well.
Thank you very much. Our next query is directed to Mr. Daruwala, and the query is that has the electrosteel judgment put the fresh slate theory at risk?
Answer is yes. In fact, that's the tragedy of our system, that there was an amendment to Section 31 trying to clarify that it is the resolution plan is binding in respect of all dues of the government. Then there was this Isar Steel judgment which introduced the fresh slate theory and said that unless the resolution applicant starts with a fresh slate, unless he knows what is the actual picture of liabilities, why will he bid for something unknown as a liability to strike later on? But this Isar Steel case is a classic example of a judgment being given without trying to see the principle behind the legislation. What this case is about is some GST dues of a corporate debtor in the pre-CIRP period. Now, the GST authorities, after Electrosteel went to Vedanta as a successful resolution applicant, they got up and they sent a notice for recovery of that dues. And they sent also a notice to State Bank, which they thought had money in respect of Electrosteel. So they sent a notice to them saying that you pay from this account of Electrosteel to us. So both the order of the GST authorities and the letter to the State Bank were challenged before the Honorable High Court of Jharkhand. But Honorable High Court of Jharkhand, instead of advancing the fresh slate theory, you can see the technical points on the basis of which it is avoiding the fresh slate theory. First thing it says is that why Vedanta, who is a resolution applicant, why is it not party to the petition? Now, it's the matter pertaining to the corporate debtor Electrosteel. So Electrosteel is the right party to the petition. Then they said that these are GST dues, which means that they have been collected by Electrosteel. So if money is collected by Electrosteel, in a way, it's like holding money in a trust, and hence this should be passed on to the department. Then they say that, you know, public announcement was not made in the state of Jharkhand. Now, whatever is IBC and whatever are the provisions that where all the public announcement is required to be made, they made it. So it is not necessary that each and every state where the creditor is, you keep on making the public announcement. Then they say that this process was not brought to the knowledge of the commercial tax authorities. And the last is the icing on the cake, which is that amendment of that section 31(1), which generally in the legal fraternity, it is regarded as a clarificatory amendment, because even before the amendment of 31(1), it was well understood that it is binding on all the stakeholders, including the central government and state government authorities. But they are trying to say that it is prospective. That is first. Other thing is that, again, splitting hairs, what the 31(1) says that it is binding on all stakeholders involved in the resolution plan. So the High Court says that you have not given notice to the GST authorities. So how can you say that they are involved in the resolution plan? So this is, I would say, a classic case of a judge ignoring the principles of the IBC, why this resolution plan concept is there, ignoring the principle laid down by the Supreme Court in the Isar Steel case, and he set his mind that this is the conclusion I have to reach, and he has given arguments to justify his conclusion.
Thank you. I now request my colleague Parth to take over. Over to you, Parth.
Thank you so much, Rushan. So now we will proceed towards taking the questions that have been posted by the audience in the questions box. So I can see we have received a lot of questions, so we'll try and answer as many questions as we can. So one question I see, which is directly, directly is posted to Mr. Daruwala. How does one deal with dictates of politicians and government to pay wages when the RP or liquidator does not have cash?
So, you know, this is a problem, but this issue normally would not arise in the CIRP process. Why? Because in the CIRP process, you would generally retain the employees. And you would continue the business hoping that there will be a resolution applicant who will take over the business. But there could be a problem in the sense that the wages may be unpaid, and there could be a situation where you have essential services and wages. So between essential services and wages, you may still have to pay essential services in full, because as I said earlier, that if you don't pay essential services during the moratorium period, then the provider of essential services can stop. So if you have a conflict between who to pay, then definitely essential services should be paid first. But in CIRP, one good thing is that you will continue with the people. Now, when you don't get a successful resolution applicant and it moves towards liquidation, then in that particular case, the first principle which is laid out in section 33 subsection 7 is that all the employees are discharged. And then it says that you can continue with the employees so long as the decision is to continue the business. So the meaning of this should be that the employees stand discharged on the date when the liquidation is ordered, but the employees will continue if the business is continuing post the date of the liquidation order. But after the date of liquidation order, for some reason, the business has to be discontinued. According to me, the implication of this particular provision is that when you discontinue the business, the employees will stand discharged. Now, this is actually what happened in one of our cases, where we continued the business after the liquidation, kept the employees, but because we couldn't continue for long, the cash had run out, we discharged the employees. But then the local politicians and the government authorities came in and said that, no, don't discharge, keep them with you. Now, frankly, that is not permissible, because IBC itself contemplates that they will be discharged, number one. Number two, you can't continue the employees in a manner that you deplete the value for the creditors of the business. So I think this is a real issue where you see the politicians and bureaucrats trying to sort of fulfill their social objective of continuing with the employees, even if the commercial justification is not there for continuation. But our advice is that, in view of the IBC provisions, I think their arm twisting tactics should not work legally.
Thank you so much. So I can see there's one next question which is specifically directed to Ms. Iyer, and it's a very interesting question, I feel. So the question is it is often seen that RP does not like to take decision against the wishes of COC. So do you think there is a need to clip the wings of COC?
Yeah. So actually, yes, one often hears and even observes RPs complaining that COC expects RPs to toe their line for everything, even if what the COC is saying is contrary to the provisions of the code. And if one does not toe the COC line, there is a covert threat to either change the RP or not engage them for future transactions. We have also seen cases where RPs have been changed because they have refused to toe the line. And actually, when the code was framed, it was contemplated that the financial creditors would play a mature role and they would protect the interest of all the stakeholders. But however, unfortunately, in practice, we have seen that this is an exception. In most of the cases, now we are always told IBC is not a recovery mechanism, but all of us know that COCs are only concerned with recovery of their money and their own interests, and they are rarely concerned with the interest of the other stakeholders. In fact, many a time openly they talk about recovering their money. So they continue to view IBC as a recovery mechanism. So in my view, it's a personal view, I think there is a need to review the power given to the COC to appoint, remove and change RPs. So what I think is, one should consider whether this should be done by an independent regulator like IBBI. So if a COC wants to change the RP, they can pass a resolution, but the final decision should be taken only by IBBI. And I think this will be a very good, even the decision of appointing should be going, like we had that earlier discussion of appointing your own officials. So I think IBB should be given more, a larger role in appointment, removal of and change of RPs. And I think this will be a very good step to ensure that these RPs are truly independent and they take care of the interest of all the stakeholders. Yeah.
Thank you. So the next question is directed to Mr. Daruwala, and it's a very relevant question in today's scenario, in the situation of COVID. What was the impact, and what is the impact of lockdown on the implementation of resolution plans?
See, this when NCLAT it passed an order excluding the lockdown period, what it said is that only the period of the CIRP, and as I said, the period of CIRP is this 180 days and 270 days is gets extended. Now there is also a period after submission of resolution plan, because 180 and 270 days, as I explained, is the period within which you submit the resolution plan. So there is a period after the submission of resolution plans that the resolution plan will get approved, and thereafter it has to get implemented. Now, even when we see Regulation 40C, which was brought about, so it said that lockdown period shall not be counted for timeline of any activity under the CIRP regulations. Now, if you see the timelines, then there is a model timeline in Regulation 40A. But that timeline, stops with the approval of the resolution plan. But after the approval, also we see that long time elapses, particularly when the court orders approving the resolution plan are challenged. So the problem is that actual CIRP ends on the transfer date. But unfortunately, the regulations and the law is not considering the CIRP period up to the transfer date. And as a result, this extension of time because of the lockdown, many CIRP closings had to necessarily happen with all the difficulties, and time was not extended. But we had a recent case which is FM Hammerl Textiles Limited, where the resolution applicant approached NCLT Chandigarh, and it excluded the entire lockdown period for purpose of implementing the resolution plan. So I would say that if you extend CIRP period up to the transfer date, a lot of problems will get solved, including the continuance of the RP from the date of order of NCLT till the actual transfer date, and continuance of the moratorium. So that would be a very strong recommendation for the IBBI to do.
Thank you so much. So we will take one more question, and the question is directed to Ms. Iyer. Will a bank who is beneficiary under obligor and co-obligor agreements be a claimant in respect of each of them?
Okay, so to start with, let me explain first what is this obligor co-obligor agreements, because we are seeing substantial large number of CIRP proceedings where these arrangements are there. So suppose there is a group of closely held companies. Each company is an obligor or a borrower for the borrowings of all the other group companies, and each company will provide a charge over its assets to secure the borrowings of all the group companies. And this is what is called it's called cross collateralization. And we are currently seeing several CIRPs in progress where there is this kind of cross collateralization, and these are called obligor co-obligor arrangements. Now, if you ask me now, I have come across two types of arrangements. One arrangement is where the original obligor co-obligor structure is truly beneficial to each of the group companies. So their activities are very intrinsically sort of connected. And so all of them have undertaken that we will borrow and for all our borrowings, each and every other company of the group will be liable. And similarly, for whatever assets we have, we will provide that as security for the loans of all the group companies. And in these structures, you have always found that each and every group company has got some benefit or the other from the obligor co-obligor structure. So in this kind of structure, I have absolutely no complaints. But there is a second type of structure which is also quite common, which is the area of concern. And what happens in the second type of structure is there is a flagship or a main company in the group which gets into financial difficulties, and it is in the point of becoming NPA. So at that time, what happens is the loans, you know, they are sort of evergreen. You give fresh loans to some group companies. It is rerouted to pay the loans of the flagship or the main company. And in this kind of restructuring exercise, what they do is they pull in all the group companies, make all the group companies the co-borrowers, and make all the group companies provider of security. So, you know, in these we have come across instances where there is a group and there is one company which is the flagship company, or 2-3 major companies of the group which have got into difficulty. There are other group companies which have been doing very well, and they have been repaying the debts, they are operating profitably. But because of this obligor co-obligor arrangements and this restructuring, which is perceived by many as evergreening, what happens is you put this assets and the secured creditors of this other group company which is performing well also at risk, and you make them liable for the liabilities of all the other group companies which are defaulting and which have large exposures. You also create a security over this company's assets to secure the obligations of all the other group companies. So here there have been two kinds of objection. One is the shareholders of the good companies have been objecting, saying, look, my company was doing very well. Why did you enter in, you lenders and the promoters enter into this kind of transaction and put me to a loss? And the other group is the existing creditors of the good companies have been complaining, saying that, okay, they were repaying my loan, but the minute you did this restructuring exercise, they started defaulting on my loan. So I think this is the area where there is going to be a lot of scope for challenge, and a lot of disputes will arise in future. I hope I've answered.
Thank you. Yeah, yes. Thank you so much for the answer. I can see there are still a lot of questions which have been posted in the question box, but we have already exceeded the time limit. So the questions that remain unanswered, we'll try and answer those questions by way of email at the earliest. So I'll proceed towards the closing remark for the webinar. So today in our discussion, we tried to find answers to some of the issues which truly can be said to be the gray areas in IBC by producing the provisions of the code, the true intent of the legislature, and some relevant judgments which touch upon the issues in questions. And we hope that we were able to clear the air surrounding all these issues we discussed today. And we were able to give some interesting perspective on the gray areas under IBC. And we hope that industry representatives, as well as the representatives from the professional bodies in our audience today, would take up these gray areas with the IBBI. With these parting remarks, we would like to wrap up for the session today. On behalf of Vaish Associates Advocates, I would like to extend sincere thanks to all the attendees for taking out their precious time to participate in today's webinar. It has been a pleasure to host this session, and we would be happy to have some valuable feedbacks from you all. I would also like to thank our esteemed panelist, Mr. Daruwala and Ms. Iyer, for their valuable and enriching insights and experiences on these gray areas. We are also holding some interesting webinars in the days to come, like do's and don'ts for directors of companies. And the details of all the upcoming webinars are available on our LinkedIn profile, and we would be grateful for your participation in the same. Thank you very much to one and all, and have a good day. With this, we wind up the session. Thank you.
Thank you.